This is docket number 0256, the Solid Rock Church versus Public School MS 147. Ms. Court Porter, can you tell us why we're here today?
Absolutely. Your Honor, this case involves a local church who needed a place to hold its Sunday worship services. In this case, Your Honor, the church used the school building that lived next door, MS 147. The church and the principal of the school came to an agreement to use the school's auditorium to host its Sunday morning worship services. After 3 months, the PTA organization of the school implemented a policy which prohibited permits from being granted for the purpose of holding religious worship services or otherwise using a school building as a house of worship. And now the church brings suit as a violation of their free exercise clause, and the school raises an affirmative defense of the Establishment Clause.
Upon reviewing the record, judgment for the plaintiff.
Woo! Your Honor, this is absurd. I'm gonna appeal this decision.
Order my petitioner when you're ready.
Madam Chief Justice, may it please the court, my name is Brianna Enck and I represent the petitioner MS 147 in this matter. Your Honor, allowing the Solid Rock Church to hold its worship services in a public school building is a direct violation of the Establishment Clause. The Establishment Clause of the First Amendment prohibits the government from aiding religions or preferring one religion over another.
Counsel, is there any aiding here? I don't see how the school auditorium amounts to aiding a religion.
Your Honor, allowing these services will amount to aiding, since the school will incur expenses as a result. Moreover, in the case of Engel v. Vitale, a public school compelled an official state prayer from students. Although that case did not involve any financial aiding of religion, this court nevertheless found a violation of the Establishment Clause.
Counsel, where in the Constitution does it say that encouragement of religion is enough to violate the Establishment Clause?
Isn't that too low of a bar, counsel?
And are we going to allow blanket discrimination against religious entities simply because we're afraid it will encourage religion?
Of course not, Your Honor. Our Constitution does not support discrimination. Instead, the Constitution guarantees that government may not coerce, support, or participate in any religion or its exercise. This was the court's ruling in Lee v. Weissman. Moreover, this court in Santa Fe School District v. Doe held that religious activity on government property or in government-sponsored events was a violation of the Establishment Clause. Here, the worship services will be taking place on government property, the school's auditorium, and it can easily be seen as a school encouraging the religion on its property.
But counsel, you've given us a lot of policy arguments, but where is the law? Where can you show us that the law states that this is a direct violation as you claim?
Well, Your Honor, in Lemon v. Kurtzman, this court set up a clear three-factor test to determine whether state action violated the Establishment Clause. Here, the school's policy passes constitutionality according to this three-factor test. The above reasons, petitioner asks you to reverse the lower court ruling and find in favor of the middle school. Thank you.
Thank you, petitioner.
Counsel.
Respondents, when you're ready.
Madam Chief Justice, and may it please the court, my name is Gregory DeSantis, and I represent the respondents in this matter, Solid Rock Church. Allowing the Solid Rock Church to hold its worship services in MS 147 does not violate the Establishment Clause.
Counsel, what law supports your argument?
Your Honor, in the 1993 case, Lamb's Chapel v. Center Marquez Union Free School District, this court found that the Center of Marquez School District permitted Lamb's Chapel to use the school's facilities for after-hours religious-oriented film series. There would be no violation of the Establishment Clause.
Counsel, could you tell me about Good News Club versus Milford Central School?
Yes, Your Honor. In Good News Club, this court held that when Milford denied the Good News Club access to the school's limited public forum on the ground that the club was religious in nature, it discriminated against the club because of its religious viewpoint in violation of this free speech clause of the First Amendment.
But counsel, as Justice Stevens argued in his dissent in Good News, speech for religious purposes encompasses 3 different categories.
Yes, first there is religious speech, that is simply speech about a particular topic, a religious point of view.
And second, there's religious speech that amounts to worship.
And third, there is the speech that is aimed principally at instilling a belief in a particular faith. Doesn't Solid Rock Church services fall under category number 2 and 3?
No, Your Honor. The religious speech of Solid Rock is not aimed principally at inculcating belief in particular religious faith. Here, Solid Rock is not calling children to commit themselves or convert to Catholicism. The services here were held in the middle school, but did not call for the students in the school to participate. For foregoing reasons, this court should affirm the decision of the lower court.